Меня зовут Александр Кукуев, я управляющий партнер Uppercase Legal. Мы вещаем из офиса Uppercase Legal в Объединенных Арабских Эмиратах. Сегодня со мной Махмуд Селим Аль-Хашми, господин Сергей Левичев. Господин Махмуд Селим Аль-Хашми – Associated Partner компании Uppercase Legal и глава практики, связанной с риск-менеджментом. Глава практики разрешения споров Сергей Левичев. Пару слов буквально о спикере сегодняшнего мероприятия, господине Махмуде Селиме Аль-Хашми. Господин Махмуд Селим до присоединения к команде Uppercase Legal управлял на протяжении нескольких лет офисом Кобри & Ким на Ближнем Востоке. Компания специализируется на санкционных режимах, снятии санкций. До присоединения к компании Кобри & Ким господин Махмуд Селим был главой компании Питер Мейсон и DLA Piper. Открывал офисы на Ближнем Востоке, в Израиле, в Лимассоле. Сергей Левичев будет сегодня модерировать разговор с Махмудом Селимом. До присоединения к команде Uppercase Legal был топ-менеджером компании ВТБ банк в Москве. Закончил школу права в Нью-Йорке, имеет широкий и давний опыт работы с санкциями. Сегодняшний вебинар посвящен санкциям и эффективным методам борьбы с санкционным режимом. Мы начнем с того, что я расскажу о том, как будет выглядеть сегодняшний вебинар. Я передам слово Сергею Левичеву. Сергей задаст вопросы господину Махмуду Селиму. Мы поговорим минут так 45 и дадим возможность задать вопросы аудитории. Передо мной есть iPad, на котором я смогу увидеть вопросы, задаваемые в чат. И как вам будет удобно, на русском или английском языке, вы можете, соответственно, в чате задать мне эти вопросы. Мы не планируем публично выкладывать запись указанного вебинара, но для желающих мы можем отправить ссылку после окончания этого вебинара. Небольшой дисклеймер. Этот вебинар не является legal advice. Это вебинар исключительно для образовательных целей, академического характера. Любые legal advice могут быть, соответственно, заказаны у компании в отдельном порядке. Мы также хотим обратить внимание аудитории, что мы не занимаемся взяточничеством, мы не нарушаем законодательство ни Российской Федерации, ни Соединенных Штатов Америки. Я передаю слово Сергею Левичеву, который представит господина Махмуда Селима Аль-Хашми. Спасибо всем, кто присоединился. И задавайте ваши вопросы в течение вебинара и по прошествии.
Dear all, we are switching to English. Today, we are glad to host our associated partner, Mahmoud Selim. Just a few words about yourself, about your background, about your education, just for our listeners who first time having a webinar, you seeing your first time. So the floor is yours.
Thank you, Sergey. Thank you, Alexander, for hosting me today. Hello, everyone, and greetings to all. Thank you for dialing in, and such a pleasure connecting with you virtually, and hopefully connecting with you in person, whether in Dubai or anywhere else in the world. A few words about myself. My name is Mahmoud. I am a lawyer by background. I've been practicing law for over 23 years. I am what they would call in England a barrister or a trial attorney in the US. So I go to court and I do advocacy work. I, in a previous life, was a national security prosecutor and then a national security magistrate, investigations judge. Made it all the way to being deputy attorney general. National security, my focus back then was transnational organized crime, countering terrorism finance, and anti-money laundering. And then when I became Deputy Attorney General, I became a member of the Technical Bureau of the Attorney General, and heading the International Judicial Cooperation Department. So a dash extra was added to my mandate and scope of work, which had to do a lot with sanctions and cross-border interagency work. So a lot of Interpol, extradition, and the likes. I read law in the region, in the Arab world. I'm qualified in civil law as well as Islamic law, Sharia. And then I went and did my master's degree, international and comparative law, so it was a common law degree. And then I read law all the way to my PhD with Queen Mary College, University of London, in political economy and law and economic development. So there was a lot of focus on sanctions and the role law plays in economic foreign policy and the economic development as well as economic warfare. So that's me in a nutshell. Again, thank you for hosting me. Before we move on to the questions, I would please, if I may, have a few minutes to talk about what we're doing together as a group of professionals here in Dubai, our practice, our offering, and where do we fit in the grand scheme of things. So what we're doing, Uppercase and us, is that we're trying to create value for our client. We're not in the business of selling law. We're in the business of creating value, which means that we are interested in solutions. We're problem solvers, working as part of a team. So each one of us brings to the table a unique, distinct skill set. And with that, the sum of us is a solution. We're problem solvers, and we try to be cost efficient, time saving, and business friendly. We're not interested in typical orthodox paper pushing applications. We would like to do it the right way. We would like to do it in a time saving manner and in a cost efficient manner. And we like to do it as a team, as part of the team, working with the client, with their advisors, engaging critically, thinking together how to create value. So that's the raison d'être. This is our reason for existence. This is why we do what we're doing. So that's the why. What do we do? The what is basically we're trying to manage risks in a world that is in a state of flux. So we work with IPCs, international private clients. Those could be defined as ultra high net worth individuals, people in high political office, be it heads of state like presidents or kings, or heads of government like prime ministers, members of cabinet. We work with family offices, we work with financial institutions, banks or funds. We work with celebrities, we work with members of royal families. So this is the target audience, the clientele, IPCs. And we work with them on special situations. 2 capital S's, special situations. And we define a special situation as an event that has a material adverse effect on someone's liberty, wealth, and or reputation. Something happens and the government is coming after our client, and now there is a risk of apprehension, incarceration, and or extradition. And what we do is that we step in and we create a safe zone. Basically, a safe zone is a legal creation where the client and their immediate families and their business associates have immunity, obtain immunity from getting arrested, spending time behind bars, or extradition. We do this by a multiple of ways. CBEs are examples, sovereign intervention, etc. So that's liberty. Wealth. Wealth preservation is basically what we're trying to do. And we do asset restructuring, asset relocation, asset conversion, succession planning, with a view of handing over the management of the company or the business or the assets
to someone who's less controversial, and in the meanwhile helping the client deal with the underlying legal causes of the problem. This, of course, we got very busy with sanctions and asset seizures because this is part of asset preservation. Of course, the time of intervention is super, super important, and this is, please, and I'm sure all the audience appreciate this, proactively managing these situations is crucial, because once there are sanctions in place, we really might be limited in terms of what we can do in terms of asset preservation, because then we could easily be perceived as trying to circumvent sanctions. Lastly, reputation. And we do reputation management, both offensive as well as defensive. And this is super important and the building block really with regards to sanctions relief as well as asset recovery, because we usually deploy asymmetrical strategies, advocacy basically. We do a lot of forensic audit reports to examine the books and records to be able to showcase what the client is actually doing, clean funds analysis reports, national security alignment. I'll talk about these strategies later on, but anyways, that's part of the reputation management in support of the legal applications we make. So basically, what is reputation management? Reputation management is advocacy done within clusters of decision makers in favor of our client to change perception, leading to the changing of the decision. So I am listed on the SDN because they think I've done something wrong, or because that they think that what I am doing does not align with their national security. We step in and tell them, listen guys, you got this wrong, this is what's actually happening, so that they can reverse their decision. So 3 pillars: liberty, wealth, and reputation. So that's what we're doing in a nutshell. Again, I'll stop here. Lawyers have the tendency to talk a lot. Back to you.
No, actually, just for our audience, how this idea came up to our minds, we have been receiving many requests from our clients with the request to assist them in lifting the US sanctions, especially the US sanctions, because their assets have been frozen since the date when the sanctions were imposed on them. We have a very sophisticated audience today, so if you don't mind, we will stick to our questions, because we actually received before our webinar some of the questions, so some of the questions will be from you. So could you briefly explain what legal avenues does the sanctioned person have in order to lift the US sanctions?
Yes, certainly. With pleasure.
What are the approaches?
Yes, with pleasure. So basically, the standard process is that you file for complementary information with OFAC, so the Office for Foreign Asset Control, which is part of the Department of the Treasury. So the decision makers within the US, I'm just talking on US sanctions, you have to think about the Department of Justice, where the FBI and the National Security and the Attorney General sit. The Department of the Treasury, which is OFAC is part of. The Department of State, which would dictate US foreign policy, because economic sanctions are part of economic foreign policy. And then the White House. So all of these people form the National Security Advisory Team, which will then communicate to the White House whether we want to put someone on the SDN list or not. So these are the stakeholders, basically. So
could we repeat them once again?
Yes, certainly. So there is OFAC, Office for Foreign Assets Control, which is part of the Department of the Treasury.
Okay, first.
And then there is the Department of Justice, which will have the FBI, the Attorney General's Office, and the National Security Team. So National Security, they report to the Attorney General. The Attorney General reports directly to the President as well as the Secretary of Justice. And then you have the Director of the FBI. Then you have the Department of State, Foreign Ministry, the Department of the State, which will dictate and strategize foreign policy. All of these people combined sit with the White House and the National Security Advisors to the President to formulate economic foreign policy, including economic sanctions, because we need to always remember economic sanctions are part of the country's foreign policy. So these are the stakeholders. So where do we start? Well, where do we typically start? People typically start with filing with OFAC for complementary documentation. So basically,
Request for information.
request for information. They give you some information. Usually it is not complete. So then you make a request with something called FOIA, F-O-I-A, Freedom of Information Act. So again, this is with the Department of Justice. So you say, I am entitled to know what you have against me.
What were actually the grounds?
Yeah, because they don't tell you what are the grounds. And when you went to OFAC for extra documentation, they didn't give you the full picture. So then you say, under the Freedom of Information Act, I have the right, I am entitled to know what are you holding against me. So we go and we make a filing. We call it a FOIA request. FOIA, F-O-I-A, Freedom of Information Act request. So we file. Then we go back to our office and we study now. We study for the complementary documentation we got from OFAC. We study all the information and now the whole dossier, the whole file we got under the Freedom of Information. All of this takes time, of course. Just to file and then them to come back to you and then to release the information. Sometimes the national security, CIA or the FBI or the Department of State, they say, well, we cannot give you because there are exceptions under the Freedom of Information Act. If something is classified as national security, it's not going to be released. So anyways, let's say goes smooth sailing and they give you the whole dossier. We go back and we start studying. Once we do that, we make an application now why we think our client should be removed from the SDN list. We make that filing with OFAC. So now this is the second time we go to OFAC, guys, just to remember. First, we went for the complementary documentation. They did not give us the full picture. We went to FOIA for requests. Let's say they played along and they said, yes, release everything. We now went back to the office and we came the second time to OFAC. OFAC, this is why we think you got it wrong. Please remove our client from the SDN list. So we make a filing for reconsideration. So this is called filing for reconsideration. The first filing was called complementary documentation. Second filing is called reconsideration. So you file for reconsideration. OFAC then sits on it. Now, when you file these things, they need to come back to you, acknowledging your filing, acknowledging your application, you're acknowledging your request. So they just send you an acknowledgement. Then they don't come back to you.
How long it may take?
It might take months, years, or a week, or 2 weeks.
You know, it's interesting that on the official website of OFAC, you can find the information that as soon as you file a request for information,
Yes.
we are sending a questionnaire to you for you to reply. And this will happen in 90 days.
Yeah.
And they are saying in the same article that we may extend these 90 days.
Exactly.
So it may take even 4 or 5 months only to get information and to get the grounds why you were put on sanctions.
100%. 100%. This is a huge problem, number one. Number two, they might even prevent the lawyers or your advisors from getting paid.
Right.
Because why? The client is on the SDN list. The client can't legally, officially under US law to pay. So once you're on record, they say, oh, hold on a minute. The lawyers or the advisors, you cannot collect fees from this particular client unless we give you a special license to get paid. So the delays happen twice. One, they don't get back to you and they keep extending the 90 days grace period. And number two, they don't give the special license to the advisors, be it the law firm or whatever, the lobbying firm in the States or whatever it is, to make them stop helping you. So I know that the website says 90 days, but also the website clearly says that this might be extended.
Right.
indefinitely. And they exercise discretion, absolute discretionary power. So let's say they take 6 months, no response. You follow up, and each time you follow up, they respond with an acknowledgement email. Oh, dear Mahmoud, we acknowledge your email. We'll get back to you within 90 days as per section. Yes? 90 days goes by, I follow up. Oh, dear Mahmoud, thank you for following up. We will get back to you. If you keep nagging like a bad person, they might send you a follow-up questionnaire. A year goes by. You've now spent $2-3 million in fees. 12 months down the line, nothing is happening. So what do? We go file something called a mandamus application.
What's that?
It's an application in court to compel the administration. So remember, in the US, a building block of US constitutional law is separation of powers. There is the executive, there is the judiciary, and there is the parliament, Congress and Senate, the legislature. So now the administration, the executive power, represented here by OFAC, the Department of the Treasury, is from our opinion violating our human rights. They're not giving us a yes or a no. Just give me an answer. Yes, you're exercising power, but within exercising power, there is rule of law. You're answerable to law. So you go make an application with the judiciary now to exercise something called judicial review, which is called the mandamus application, just to compel a decision.
So it's a kind of chasing application.
Yes. But now OFAC cannot push it along. If the mandamus application is successful, OFAC needs to give an answer, either yes or no, otherwise they are in contempt of court. So you make a filing for a mandamus application to compel a decision. The judge then gives you, yes, OFAC, I am compelling you, I am forcing you to go back to Mahmoud with either a yes or a no. Winning a mandamus application does not mean, oh, that glory be or happy days, we're being removed from SDN. No. It means that OFAC give him an answer.
To provide you with information that you requested.
To provide you with a decision. So it's to compel a decision. So this might take another 6 months.
And they can appeal.
They can appeal. They can go to the Supreme Court. So let's say you win the mandamus application, Court of First Instance, Court of Appeals, Supreme Court. 6 months down the line, another couple of $1 million. And you have a decision compelling OFAC to give you a decision. I go to the Department of the Treasury, I go to the OFAC and say, here is a court order compelling you to give me a decision. Okay, we'll get back to you in 90 days. They come back to you with 90 days saying, we will not remove you from the SDN list. Why? National security.
Okay.
What do you do then? You go back to the federal courts and to challenge the decision. Sorry.
Yeah. So, can we get to the just news that were released last week? Maybe you've seen it.
Yes.
It's CNBC News.
Yes.
There is an article saying that the Trump administration lifted the sanctions imposed on Ms. Rottenberg.
Yes.
We do not see anything else in the media saying that which approach did she take in order to get the relief. And also, but we can state exactly that there is no court case filed by...
We can confirm that there was no court case. The approach is hybrid. Hybrid. So the correct terminology is a hybrid approach. What is a hybrid approach? Which is what we usually would recommend to our clients. If you guys remember, from the beginning we said we are problem solvers. We want to create value. We are not in the business of selling law. We want to create value for you. Time efficient, cost saving, and business friendly. A hybrid approach. What does that mean? We need to follow process. At the end of the day, we are lawyers and we need to follow process. So we will make the application with OFAC for the complementary documentation. They will not give us everything. So we will make the FOIA request, which is the Freedom of Information Act request, get the whole file, and then make the filing with OFAC for reconsideration. So 3 applications, these are 3 legal applications made officially on record, will be filled in. So this is typical. Once that's done, we need to then do advocacy work. What is advocacy work? So we go, and if you remember the stakeholders we talked about, the OFAC team, Secretary of the Treasury, the Department of the Treasury, the National Security and the Attorney General, and the Director of the FBI, Department of Justice, the Department of State. And we start doing offensive reputation management, strategic advocacy, which is basically, 1, we talk about national security alignment. The US, you think that your interests, your national security, runs contrary, it's in conflict, it is clashing with what our client is doing. This is wrong, and this is why we think it is wrong. You have a misunderstanding. So national security alignment. Local market focus. All of these people, Americans, here is a study that we prepared with professionals, with the client team, explaining what is the client doing and which markets they're focusing on. They're not hurting your businesses, they're not hurting your national security interests. So local market focus and geographical analysis. Independence from government ownership. Maybe you think that I should be on the SDN list because I am owned by the government or associated with a specific regime. This is where you got it wrong. Here is the corporate structure. Here is the who are the UBOs? All of these things. Client portfolio review. This is what we've been doing in the past. This is what we are doing currently. And this is what we plan to do in the future. There is something called harmful activities assessment. Here is our assessment that whatever the client is doing does not run in contrary or in conflict with US national security, be it internal or foreign national security. And then we do something called strategic communication support, which has to do with future enhanced compliance commitments. Basically, the Americans would then come back to us and say, okay, we understand all of this. In the future, if we lift you, if you remove the client from the SDN list, would they commit that they will comply with these requirements? So we do the dance. It's a negotiation now, becomes a dialogue. And it's called enhanced compliance commitments. So basically, we enter into an agreement on the back of which the client is removed. So usually we work in terms of days. So basically, we tell the client, let's start an engagement for the first 100 days, like the American administration says, what have you done in the first 100 days? So we'll follow the American strategy. 100 days. From day 1, I'm on the clock. Clock starts, like in playing chess with Garry Kasparov. Clock starts, 100 days, I'm on the timer. I will be making the OFAC complementary filing, the FOIA request filing, the OFAC reconsideration filing. We need to work with the team on all of these things, huge reports. We're going to be producing a mountain of documents for the national security alignment, the local market focus and the geographical analysis, the client portfolio review, independence from government ownership, the enhanced compliance commitments, all of these things. This is a mountain of documents.
This can be done in 100 days?
We will have to do it in 100 days, and then we start discussing and get the client removed. So again, we're not providing, again guys, for the record, we're not providing advisory or legal advice or consultancy services with regards to sanctions. This is only for educational purposes. This is an academic discussion. But ideally, in an abstract scenario, this is what we would recommend. And again, none of us is involved in within the team of for the lady that you just mentioned and in the news reports today. But as you said, Sergey, correctly, there has been no cases. There has not been a single court application. And given that Donald Trump and the Trump administration has only been back in office for less than 3 months, it means that the dialogue has been opened immediately and already, and within the 100 days, not only her team was able to make those applications, but also to do the reports. And the result, as we can see, she's been removed, lifted from the SDN list.
So you believe this is the right time?
This is 100% the right time and the right approach. Yes.
Okay.
As the case shows.
Yes.
Yes.
So there are the signs.
Yes.
Of changing the situation.
100%.
Is the procedure different for legal entities and for physical persons?
No, it's the same.
If we talk about the frozen assets,
yes,
is it a separate application that should be filed, or it goes automatically after the sanctions are lifted?
It's a consequence. So asset seizure are part of sanctions. And if we have time, please, I would like to go back to the drawing board and explain very briefly what are sanctions, because asset seizure is part of sanctions. So it's a consequence. So if I am put on the SDN list, a consequence of that is that my assets are seized, be it movable or immovable. So if I am removed from the SDN list, a consequence of that, an offshoot of that, is recovery of the assets.
But as it said,
we have to run paperwork.
Yes.
But it's the same application.
Yeah, but as it said on the official website, as soon as the sanctions are lifted, you are allowed to file a separate application to unfreeze your assets.
Yes. So these are the paperwork we need to do, but it's as a consequence, and it cannot happen. So we cannot make a filing for
simultaneous.
Yeah. You need to start with first sanctions relief, then followed by asset recovery.
Getting back to the stakeholders, is it a kind of decision of one authority, of one person, or this kind of combined?
It's a decision by committee, I'm afraid. So we need to really rally the forces. At the end of the day, the decision rests with the top of the administration, of course. But all of the stakeholders need to be in agreement, or at least, so there is a lot of consensus building to be made.
Can we talk about our team?
Yes.
And how can we bring value to our clients?
Yes.
And who will be doing this advocacy work on the US side?
Yes, so certainly. So we're sitting in Dubai, the three of us. We are regulated by the Dubai government as advisors. The firms are regulated by the Dubai government as both legal advisors as well as consultancy firms, and we have the ability to accept the mandate and then work with channel opportunity partners, COPs, channel opportunity partners in the US or in the UK if we want to talk about UK sanctions, or in Europe if we want to talk about EU sanctions. Now, the reason why we structured it this way, and I think this is important, is we want to use Dubai as the new Switzerland. Dubai is neutral, and as a business and as professionals sitting in Dubai, we are at liberty to provide advice and help and service to our Russian clients, despite of the US sanctions, despite of the UK sanctions, and despite of EU sanctions. Why? Because US sanctions are US law, UK sanctions are UK law, EU sanctions are EU law. So it has nothing to do with Dubai. So what we do is we get the mandate here, we sign the letter of engagement here, and then we work with our channel opportunity partners, our partners, be it in the US or in the UK or in the EU, to make those filings. So we work all together, the channel opportunity partners, the team in Dubai, as well as the team of the client, wherever they may be, to make the applications, to make the filings, to produce all of these reports, because now I'm sure that I've talked about these things. We need to sit with the team of the client, be it a bank or an individual or a company, because we really need to have a very intimate, close understanding of the business and the nitty-gritty details. So who do we, let's focus on US. I digress a lot, sorry. The US. So we have two main channel opportunity partners. I'm not sure if are we at liberty to name names?
Yes.
Yes? Okay.
Sure.
So there is Michael Sherwin and Brett Lehman. Both are the same background as me, both former attorney generals, public prosecutors. Mike was the attorney general for the state of Florida. Brett was the attorney general for Tennessee. And then Mike went on to become the attorney general for Washington, D.C. And both are registered and set up in Washington, D.C. So they have direct access. Again, as I said, our advocacy and our offensive reputation management protocol would have us that we need direct access to the clusters of the decision makers to really move things along to the benefit of our client. So in the US, Michael Sherwin and Brett Lehman are our channel opportunity partners, so they come under us. Now, the reason why they need to come under us is because, of course, everyone appreciates, both are US regulated attorneys, and the firm is in Washington, D.C., so they cannot directly engage with the client. So we structured it that way so that one, we benefit from the language. We can speak as a team, speak Russian, draft things in Russian, translate from Russian to English. Also in Dubai, we can engage directly with the client and then be as instructing solicitors to the guys in DC.
Right. And if we are at the point when we start this application process, which evidence should we provide a FAQ with in order to have the sanctions been lifted?
Yeah, we will need as much evidence as we want.
What are the criteria?
It will depend on what they have. So once we make the FOIA request, the Freedom of Information Act request, we will then know what they are holding against the client. But mainly it all foils back to the idea of national security alignment, independence from government ownership, the portfolio analysis, the geofocus, harmful act assessment, all of these things. It all boils down to national security alignment. So basically, once we have the FOIA documents, we will know what they're holding against us, and that will tell us what we need to come back with. But it all goes back to the idea of national security alignment, that we're not harming their best interests, and that we're independent from whatever they think is an enemy regime, and that going forward we are prepared to commit to complying with the requirements.
So also we will be providing some undertakings from these entities.
That's going to be part of the negotiations
of the deal.
Yes.
Okay.
Yes.
And just guessing, from which sectors of economy do you believe the clients may have better chances to lift the sanctions?
That will depend on the timing.
Of course, it should be considered on case-by-case basis.
100%.
But
100%.
probably if it is a military sector, probably
those will be the last.
in the queue.
Anything with technology that has to do with military applications, private defense contractors, people in cybersecurity. These, again, I'm being speculative here, so please don't hold it against me. I'm being simply speculative, but I think those will be the last, simply because of, as you said, as you rightly identified, they have a direct military application, so they might put a lot of noses out of joint, and they will be the last. But The most important. So the easiest would be if someone has been put on the list, unfortunately, as part of a sweeping brush. Someone woke up in the morning and said, put all Russian banks on sanctions, regardless of what they're doing. So I've just been sanctioned, or just put all Arabs on sanctions, and I've got put on sanctions simply because I'm Arab. So those would be the least problematic. All cases are problematic because, again, there is a lot of paperwork to be done and applications to be made, but those would be the least controversial. The most challenging, a real uphill struggle, would be those with direct military application, of course.
We can see now that the situation is changing with the Trump administration, and the Russian business is taking a kind of holding stance, and they're just looking at the situation and they're thinking that probably the sanctions can be lifted without our input, without our applications. Do you believe this may happen?
No.
So they will still, even if any kind of treaty is signed, still they will have to file this application that
Let's
we
say
were talking about.
Tomorrow morning we all wake up and we live in a state of global utopia and we're all happy and we're going to sing Kumbaya together. And the Trump administration says all sanctions lifted. Still, each single legal person, be it an individual, a natural person, or a body corporate, a juridical person, would still need to go make an application. Because my name needs to be removed and there has to be a document removing my specific name. My assets need to be particularly released, and I would need those documents because I need to present them to the global financial system, because I need now to be doing my banking in London, in Paris, in Dubai, in Switzerland, in Singapore, in Japan. And as we all know, the compliance teams in the banks, they will say, well, okay, I can read in the news that the US has lifted sanctions against Russia, but when I check, your name is there, and I don't have a document, a specific decree, a specific decision issued in relation to you. How do you release your assets that are seized in the US? You still need a specific application made for you to go and say, please release my assets. The difference is we don't need to produce this mountain of documents, national security alignment and geofocus and no harmful activity and enhanced compliance commitments. We're not going to need to do any of this. Why? Because now both countries are friends and the administration says, I remove sanctions. But that does not mean we don't go do applications. It will always happen. Now, is it going to happen on its own? So the answer is no. The only difference is the amount of paperwork that needs to be produced. Is it happening anytime soon? You need a magic ball to answer, but I can't be that speculative.
Do we have any questions from our audience so far?
Yes, we do. Well,
not difficult ones, I hope.
I hope not. Yeah. But thank you very much for watching us. I mean, there is a very sophisticated auditorium which is watching us. I would love to ask you for a favor. If whatever we are saying and Mr. Mahmoud Salim is stating, if it's worth for you, if you find it's effective or you like what we say, please could you just plus in the in our web chat so we would know that we are on the right track. And secondly, yes, we do have one question about the reimbursement. Um, I doubt that the question would be positive, but still, are there any procedure on the reimbursement of the costs which were borne by the applicant before the government of US after the lifting of the sanctions?
Understood, understood. Recovery of legal costs.
Exactly.
Recovery of legal costs. The answer is, and I hate to sound like a lawyer, but it depends. Recovery of legal costs, if we go to court, so if a court action is taken and we prevail, we win, then we can recover legal costs as part of the relief sought, what we are claiming in a court application. So if either we file for a mandamus application to compel a decision, or we make a challenge within the federal court system to counter or to challenge the decision by OFAC to decline the application. If, however, we run an administrative process, then we cannot recover the costs. So it will depend. The answer is it depends. A court action as part of standard, regular US procedural law, legal costs, reasonable legal costs are recoverable. However, if we run an administrative process, then costs are not recoverable.
Understood.
And we are aware of one case that was brought before the US federal court. The case was brought by the former members of the board of bank at Kriti. The case was brought in June, and in July we got aware that probably the parties negotiated the out-of-court deal.
Yes.
So probably in this case, at least they were negotiating the costs that the sanctioned
100%.
persons spent on their lawyers.
Yeah.
Well, there are. I doubt that the question is related to the sanctions, but still, I have to ask it once it's been put over there. So the question is: there is a company registered in UAE and for a while, but it's owned by a Russian national and an UAE resident. Okay, so another company in UK that owes a significant amount amount of money to this company in UK. So UK lawyers, they refer to sanctions, and they cannot onboard the client, referring to the Russian UBO, saying that UBO does not allow them to onboard. So can the UAE client be onboarded? The Russian national and the resident can be onboarded on in our company as a client, and our company engages with the UK lawyers. So is it possible?
The answer is absolutely yes. This is exactly why we're here. We're to help you guys. We are 100% in compliance with UAE law, and UAE law allows us to engage and accept instructions from Russian clients. Of course, we need to comply and we need to decide on a case-by-case basis because there is the business sensitivity aspect to consider. But the answer is yes, we can. So what we do, in addition to, if I may, to digress, apologies if my answers are a little bit longer than anticipated, we do something called claim monetization as well as claim dilution. So what Mr. Kukuev just mentioned or just referred to is claim monetization. Basically, the creditor is the Russian UBO or his or her entity in Dubai. The debtor, the guy who owes him or her money, or it owes the company money, sits in the UK. Now, because we would potentially represent the creditor, so we are trying to recover money from someone. So this is called claim monetization. And why we are calling it claim monetization? Again, back to our approach to advisory. We don't want to waste anyone's time and money. So the answer is yes, we can get instructed. How do we approach it? Immediately, we do something called asset tracing exercises. So we work with private investigators and with cybersecurity specialists, and we look at the defendant, the potential defendant, the debtor. And we see where they hold their assets in the UK, outside of the UK, in Europe, in the Arab Middle East, in the Middle East in general, Israel, Turkey, Iran, elsewhere in the world, India. What kind of assets? What can we collect intelligence on them that we can use as pressure points? And we start deploying asymmetrical strategies, meaning that not only do we go and apply for a claim in court in the UK, but also we can start a negotiation strategy. We approach the potential debtor and tell him, listen, or her, we have these things against you. And now we can go and apply for a worldwide freezing order from the DIFC courts, for example, or the ADGM courts. We can go and create havoc. We have a lot against you. Why don't you come to the table? And instead of us spending money and the next 2-3 years in court, just come to the table now and let's settle out of court. So again, claim monetization because we're trying to help the client be time saving and cost efficient and business friendly. But the answer is yes. And if we need to file a claim in English court, uppercase can act as the instructing solicitor. And that's perfectly fine in the UK.
Very good.
And probably that would match their goals, because sometimes this is a kind of policy of a UK company not to be engaged by Russian clients or by sanctioned clients, but they will be happy to be engaged by their UAE firm. And also it would be helpful for the payment process, because it would be much easier to pay the UK lawyers from Dubai.
Yes.
All right. You have much experience in paying the lawyers all over the world, working for the Russian entity,
For the
sanctioned entity. What was your experience, Sergey, if I may ask?
Well,
was it difficult?
There are routes, then there are options
Right.
that are still working. Also, I can say that I have huge experience working on the sanctions related cases, and these cases are open to the public. These cases are against the US financial banks. So what I can say that once you bring the US company before the US court, it will be a long procedure. And it's better, especially in this jurisdiction, to sit on the table and to negotiate. This is how it works. It's better, especially when we're talking the US jurisdiction.
Right. Well, I'm so pleased to be here today with two high ranked professionals, and just to make our auditoria to know few things about you more, I would love just to reintroduce you two from my personal angle, because I've been knowing you for ages, and you two are very interesting personalities. Mr. Mahmoud Salim Al-Hashmi is very well-known professional here in Middle East, not only for being a high-valued professional in legal sphere, but also some personal family history, if I may disclose it to our auditoria. Mr. Mahmoud Salim Al-Hashmi is from the noble family of Hashimis, who have been rulers of Mecca and Medina for the 800 years. And Mahmud, being a 40th direct descendant of Prophet Muhammad, peace be upon him, and he is also Sharif of his own clan, of his own tribe here in Middle East, his family. And Mahmoud is a nephew and cousin to some royal families in Middle East, including Jordan, including Egypt, including Iraq, and others. I have a question before we go to the history of Sergey. Does it help you here in Middle East or all over the world, your noble name, this background, what Americans by partnering with you at Cobra and Kim and Pet Amazon and DLA Piper, Britishes and other nationalities, what do they find in Mahmoud Salim's history of his family, something special? What makes you think that this helps you or not helping you in business?
Um, Thank you for sharing the background. And it helps being regionally relevant. So, with a deep understanding of the region, its history, its geopolitics, the families, we are at the end of the day a tribal society. So, this helps understanding the dynamics. So, we try to bring this to the value we are offering to our clients because we are deeply rooted in the region and we really understand how it works. Also, it gives us access to certain decision makers. So we try to leverage this in favor of our clients. So in general, it has been helpful.
Thank you. Sergey, I know you for a long time, and your history and story of your life is very interesting. You studied in New York, then worked in Brazil, Seychelles, and then worked for 7 years for sanctioned bank in Russia. Now you are in Dubai. So, what are the challenges are before you here in Dubai, and how the Dubai entity, Dubai law firm, helps your clients nowadays in Russia in order to pay for other lawyers to be presented before the high courts all over the world? And basically, what is Dubai for you?
Actually, as soon as I was always in dispute resolution, and I was engaging lawyers in many jurisdictions in Europe, in South America, in Asia, and honestly, there is no difference where I am, where where I'm situated geographically, because I can do it from any point of the world. But you're absolutely right, saying that the lives of my clients has become more simple, because what is now simplified is the ways of how uh, my clients can engage lawyers in other jurisdictions, or with my assistance, I can cover and handle the disputes in major arbitration centers. And for instance, being in Russia, it's extremely difficult even to pay the arbitration fees, or just formal fees before you file a request for arbitration, being in Russia. Being here, it will take 10 minutes.
Right.
This is the advantage for the client. And also, there is still a kind of, how should I say, um, a kind of stereotype, yes, when on case which is covered by the Russian law firm, or whether it is handled by themselves, by the sanctioned persons. Because even here, as Ofak is saying, even the sanctioned person can sign the petition by himself, but it would be more advantageous if it is signed by the US counsel.
Right. Well, that all matters, and as has been stated earlier, it's a right time and right place and right people who are watching us to make the things move forward. So, just an overall and um, uh, short conclusion on what we have discussed today. So, being in the right place with the right people, with the right experience, applying to the right before the right authorities and knowing the hybrid ways of speeding up the processes, knowing how to make the advocacy working in our favor, in favor of our clients, we would state before the auditoria that yes, we can definitely help the clients to get relief of the sanctions in a fast and effective way. So this way, as you said, would be consisting out of the formal applications and what is called in US, and it's absolutely legal there, lobbying, right? Before the Trump's administration on the certain personalities who can do it in an absolutely legal way again, right? So just three things which you would recommend, Mahmoud, to our representatives of our clients. I'm sure they are here watching and listening. What would you recommend three things to consider to do in the first instance to convince the clients to go for the advocacy or lobbying route in use, the hybrid model?
One, to remember the very nature of the beast. Sanctions are economic warfare tools. So in nature, they are hybrid, legal slash political slash economic. Economic sanctions are basically penalties enforced by a country, several countries, or an international organization targeting another country, individual, a group of individuals, companies, or a whole industry, with the aim to make it almost super difficult or completely abolish the economic capabilities and the access to the international banking space for the target subject. So it's economic warfare. So the nature of the thing is hybrid, legal slash political slash economic. So with that in mind, I would please ask everyone to take stock and really think that we want to be time-saving, cost-efficient, and business-friendly. And we need to understand what we're dealing with. And that is why we need to counter the sanctions with the same approach that the sanctions were issued in the first place, which was a hybrid mechanism. So we make the filings, which are all legal exercises. You need to make those applications, and you need to get the evidence that they are holding against you, and you need to come back with your case for defense, why you think you should be removed. The difference between a hybrid approach and a more orthodox classical approach is that with a classical approach, you'll be sitting, not proactively managing the situation. You're reacting, and OFAC is going to take their good time, and they're not going to respond. All the time you're paying money because the lawyers are on the clock, and it's very, very expensive to do litigation in the US. So you're wasting time and you're wasting money. And you're going to have to go back to the lawyers, and they're going to have to make a mandamus application to compel a decision. And then the decision will come back negative. And you'll have to go back to the lawyers who are going to have to go back and file a federal challenge to reverse OFAC's decision to decline. And you're going to, again, submit the same evidence that we talked about, the same national security alignment, because that's the case. What is the case? We're all lawyers and the audience are lawyers. Your case is, I am innocent because I am aligned with national security. I'm not a threat to your national security. This is what I have been doing. I am not owned by the enemy regime. I'm not associated with the enemy regime. This is the case, right? So we're preparing the case anyways. The difference is, instead of wasting 2 years in court, we're going to make the case and go to the decision maker and say, decision maker, and we filed the OFAC application, we filed the FOIA requests, we filed the OFAC application to reconsider, so all is done par excellence. However, the difference is 2, 3 years of your life and $5, $6, $7, $8 million worth of fees saved. That's it.
Very good. One of the questions been raised while we were speaking, one of our webinar attendees just asked, so you've mentioned the cost efficiency, right, as one of the criteria of your team. How would you appeal before the authorities? So what makes you more cost efficient than others? Because knowing the Russian mentality, Russian business mentality on how to fix the lump sum, right? Instead of the hour rates. So everyone hates to pay hour rates to the lawyers, right? Because it's so flexible. People don't trust those reports, and people just always like would love to have a cap on this hour rates. What is your and your team's range of the fees? That's the question. And what makes you cost efficient in the eyes of the client?
We are cost efficient because we go for the fix. We are efficient because we go to the core issue, the underlying problem, and we fix it. We are result oriented. We want the problem gone. We are problem solvers. We are here to create solution. We're not interested of selling you law. An economic principle, put it in very simply, has it that no one wants to continue paying the plumber, the guy who comes and fixes your faucet at home. So if I'm the plumber, I will come to you and say, this is the problem, and I'm gonna fix it in 2 hours, and it's gonna cost you $10. The others, I'm not comparing us to anyone. Anyways, this is hypothetical. Someone else will come and say, oh, I will only twist the faucet, but this is only going to cost you 10 cents. He twists the faucet and then stops. Now, of course, the client said, oh, 10 cents. Mahmoud said $10. Oh, you're much cheaper. Mahmoud is too expensive. Okay, 10 cents. But 10 cents, you have to be careful. I'm sure you all read the letter of engagement and the scope of work. 10 cents, I'm going to twist the faucet. And then he stops. You know, oh, but the problem has not been fixed and a day has been lost. I'm going to come next week to make a couple of 2 more twists, but that's going to cost 20 cents. All of a sudden, a month down the line, and you've spent $100 and still your faucet is not working. Why? Because of the very basic, simple economic principle of no one wants to continue paying the plumber once the problem is fixed. So the other people, the orthodox approach is that the client is not going to keep paying me if I fix the problem quickly, if I go and fix it. So let's drag it on. We, on the other hand, go and fix it. Like the example Sergey just pointed out, that lady got her problem fixed in less than 100 days. I'm gonna put money now with all the audience willing to bet if anyone can point a court case where they got the problem fixed from get-go to the end within 100 days.
If I may add something from the client's point, because I used to be on the other side always. You know how it works. We are not saying any magic words or we are not providing any magic suggestions, because what we are saying, it's written in the US laws that you should first apply with a request for information, then you may file a petition for reconsideration. Then you may file a mandamus application. Then you may challenge. What we are saying that the US courts and the US litigation procedure is the most expensive in the world. So at the end of the day, you will spend much more in litigation rather than you will decide and to vote for asymmetrical or hybrid approach. At the end of the day, your check will be much higher.
And may I add, you will be producing the same evidence anyways. We're not saying that I'm gonna go and we fix it over lunch. We still need to produce the evidence. So anyways, even if you plan on going to litigation, you will still need clean funds analysis report, your geographical focus, your national security alignment report, your non-harmful action assessment report, your future compliance commitments, all of these things, because this is, anyways, if you go to litigation, you're gonna have to go and submit all of that in support of your challenge. So the money that's going to be spent on preparing the evidence, this mountain of evidence, is paid. And then you go to litigation. We are saying we do it the hybrid way. You don't even need to go to do litigation.
And moreover, who will be the happiest person in this process? The US attorney, because he already submitted all the papers before OFAC. And now he is saying to his client that, unfortunately, our application was denied. And the client is thinking, well, I'm in the middle of the road. So, exactly, of course, I will go and file again now a petition before the court. And the US attorney will be extremely happy about that.
Right.
100%.
Well, from my side, just the last question. I do understand how frustrated maybe the sanctioned persons, companies, lawyers are at the moment, and the sanctioned person by herself and or himself. Frustration comes from the unilateral act of the implementation of the sanctions without any court and fair um, uh, proceedings. Secondly, timing of the non-lifting them, even appealing the sanctions, but non-lifting, as you explained. So I would say people just got used to live with them in Russia and other countries. Even they are disturbing them or may disturbing them. They got used to stay with them. So all of a sudden, they have just got knowledge from this webinar, and they saw three nice-looking gentlemen. I don't mean myself; I mean the operator, and you too. And then they saw, they've seen this webinar, and they are now at the very passive stance, I would say, as the whole Russian business. They are waiting for something to happen. It either happens automatically and means the political situation happens to the better situation, and it will be automatically relieved. They will be automatically lifted from the sanctions, or we have already got used to stay with those sanctions. So, what would be your last remark on whether they should stay on this passive stance, merely observing what's going on and waiting for something, as we say, manna nebesная, to come and the miracle to happen, or they should be more proactive and to use the hybrid way of lifting the sanctions. So what would be your best advice in this scenario?
My best advice is to proactively manage any situation like we do with any problem we face in the world. If you leave a problem, it snowballs.
So it won't be automatically
Again,
lifted.
no. Again, even if tomorrow morning we wake up and the Trump administration decides that because of national security reasons, they decided to lift all sanctions against Russia and Russian interests, does not mean that a specific. Okay, another example. All Arabs are funny. Does not mean that Mahmoud is particularly funny, right? So that's why a generalization is not scientifically correct, because you cannot apply a general statement to a specific case. All sanctions against Russians are lifted. Foreign policy. Marco Rubio, the new Secretary of State, comes on CNN or Fox News and says all sanctions against Russia are lifted. each individual affected person, be it natural or juridical, would still need to go make an application to be lifted from the SDN list, followed by another application, as Sergey correctly pointed out, under US law, to release the assets. The difference is when our friend, the Honorable Secretary of State, came on Fox News and said all sanctions are being lifted, this statement constitutes national security alignment. So we are no longer in need to produce a mountain of evidence to argue a case. We simply need to rely on the decision of announced by the Secretary of State. So the paperwork is less, but we need to do the paperwork nonetheless.
What I would like to add, because we just received this question from our auditoria, who would be the ideal client for the sanctions relief process? If I may, it would be speculative again, but as I may guess and judge, it would be the entity which was included in one of the latest waves of sanctions within the previous US administration. For instance, if you look at the list of November 2024, you would see that these companies are not state-owned, they are not connected to any military or important economic sector. These companies, which are listed in 2024, it's my opinion, but they may have the better chances to be excluded from the SDN list.
Am I correct saying that, in other words, it's several banks,
Several
it's
banks.
agricultural sector,
Right.
it's probably medicine, pharmaceutical. They were never sanctioned, right? I mean, agriculture and banks.
Oh, it would be better even during the ongoing negotiations to give a good sign of relations to release any party from the sanctions list, showing to your other party that, see what we are doing.
What other industries would you mention?
Well, I'm first of all thinking about the banks that were included in this, by no occasion. Actually, there were no reasonable grounds. I'm thinking mainly,
Yeah, for
the
example,
banks.
like bank with the highest number of the correspondent banks was sanctioned just because of having the biggest number of the correspondent banks. Well, from what I see, we don't have any other additional. So logistics, banks, agriculture. Would you add anything else?
Yeah, advanced manufacturing, information technology. Yeah.
Well, the last remark, Sergey, and then Mahmoud. Would you like add anything in the end of the webinar?
We'll continue our webinars, even if you are still considering about the sanctions relief, you may still at the same time thinking of other routes how to manage your business. And next week, actually, our colleagues will arrange a webinar devoted to another topics and another jurisdictions, how they may simplify their economic routes.
Right, including Saudi and Mauritius. So keep tuned. We will be updating you on the coming events. In the meantime, I would love to thank you, today's guests, moderators, speakers, our distinguished Mahmoud Salim Al-Hashmi and Sergey Levichev, and myself, Alexander Kukuyev. We were here today for you. Thank you very much for being with us, and see you soon.